Constitution was adopted in 1789, the boundaries of suffrage were left not clearly defined. All states denied women from voting, except New Jersey, which gave women's suffrage for a brief period of about 18 years, but later revoked it in 1807. There were many scattered movements for suffrage in the early 19th century, but in 1848, the Seneca Falls Convention in New York marked the commonly recognized beginning of the women's rights movement. Led by female Quakers along with Elizabeth Cady Stanton, they wrote the Declaration of Sentiments and a list of resolutions that would become the framework for the women's suffrage movement. Now, who were these Quakers, and why were they the first to really spark the women's rights movement? To give some background, these women came from a particularly progressive group of Quakers who lived near Seneca Falls in western New York. They both practiced and advocated for marital relationships where men and women worked and lived in equality. The Declaration of Sentiments was modeled after the Declaration of Independence and consisted of similar wording, except in rewriting the phrase "all men are created equal," they wrote "all men and women are created equal." At that time, many suffrage bills were brought up in state legislatures, but were usually dismissed before they came to be voted on. The women's suffrage movement became more widely recognized after the Civil War. During the Reconstruction era, women's rights leaders pushed for universal suffrage to be written in the 13th, 14th, and 15th Amendments, also known as the Reconstruction Amendments. However, when the amendments were ratified, nothing was done about women's rights. As Western expansion continued, newly formed states of Wyoming, Utah, and Washington established women's suffrage in their constitutions. This prompted existing state legislatures to also begin considering suffrage bills. In 1869, two rivaling women's organizations took hold. The first was the National Women's Suffrage Association, or the NWSA, led by Elizabeth Cady Stanton and Susan B. Anthony. The organization condemned the 14th and 15th Amendments for their injustice to women and advocated for women's suffrage. Additionally, they advocated for easier divorce and equal employment opportunities, as well as equal pay for women. Meanwhile, the second group, the American Women's Suffrage Association, or the AWSA, was formed by a group of women's rights leaders who solely focused on gaining women's right to vote through a less aggressive stance, and they also avoided interfering themselves in other controversial issues. In the mid-1870s, the NWSA, led by suffrage leaders Elizabeth Cady Stanton and Susan B. Anthony, attempted several court challenges. However, none were successful. One legal case, known as the New Departure Strategy, was that the 14th Amendment and 15th Amendment together served to guarantee voting rights to women. However, Supreme Court decisions from 1873 to 1875 rejected their argument, so the group shifted to advocating for a new constitutional amendment. The 19th Amendment was officially drafted by Susan B. Anthony with assistance from Elizabeth Cady Stanton. It was introduced to the Senate as the Anthony Amendment by Republican Senator Aaron A. Sargent, a friend of Anthony's who was an advocate for women's rights. Stanton and other women testified before the Senate to back up the newly drafted amendment. However, it was rejected by the Senate in a vote of 16 to 34. A three-decade period known as the Doldrums followed, during which women's suffrage was not being considered by Congress and the suffrage movement died down. A series of surprising successes began in 1910 and 1911 when Western states began passing legislation granting full or partial suffrage for women. The successes were greatly due to the rise of the Progressive and Socialist parties, as well as the election of Democratic President Woodrow Wilson, who was an advocate of women's suffrage. Throughout the years following 1915, many proposals to amend the Constitution were brought before the House of Representatives, but they were repeatedly defeated. Finally, another proposal was brought before the House on January 10, 1918, and was greatly supported by President Wilson. It was passed by 2/3 of the House, but unfortunately it failed to pass the Senate with a shortage of 2 votes. On February 10, 1919, it was again voted upon, but failed by only 1 vote. In 1920, the President called a special session of Congress to bring the proposal before the House again. On May 21, 1919, it passed the House, and within a few weeks it passed the Senate. Within a few days, Illinois, Wisconsin, and Michigan ratified the amendment, with other states to follow. On August 18, 1920, Tennessee approved the amendment. Thus, the amendment was finally enacted, and the women's suffrage movement had succeeded. Perhaps the most famous court case involving the 19th Amendment was Lesser v. Garnett. In 1922, Oscar Lesser sued 2 women registered to vote in Baltimore, Maryland, believing that the Maryland Constitution limited suffrage to men and that Maryland legislature refused to ratify the 19th Amendment. However, 2 months before, the amendment was officially announced as having been added to the Constitution in August 1920. Lesser had 3 main arguments that he presented in court, but the court unanimously refuted them all. His first argument was that the power to amend Constitution did not include the amendment and destroyed state autonomy. However, the 15th Amendment was ratified in the same fashion, and the court held that since the 15th Amendment had been in effect for over 50 years, the 19th can be passed the same way. His second argument was that several states ratified the amendment when their own constitution banned women from voting, which made the ratification illegal. However, the court said that Article 5 of the Constitution held that federal decision trumps state legislature. His last argument was that the ratifications of Tennessee and West Virginia were invalid for not following rules of legislative procedures in the state. However, Secretary of State accepted the ratifications of the 2 states as valid, and therefore the court upheld that. Therefore, the 2 women were allowed to register to vote, and Lesser had lost the case.
Now for the timeline. The Seneca Falls Convention, the first U.S. Women's Rights Convention held in New York. Over 300 men and women attended. November 7th, 1916. The first female member of Congress is elected to the House of Reps. August 26, 1920. The 19th Amendment to the Constitution is signed into law, giving all American women the right to vote. December 1923. Equal Rights Amendment, drafted by Alice Paul and the NWP, introduced in Congress by Senator Charles Curtis. June 10th, President Kennedy signs the Equal Pay Act into law. July 2nd, the Civil Rights Act of 1964 is enacted. June 1966, the National Organization for Women is now founded by 28 representatives attending the 3rd National Conference of the Commission on the Status of Women in Washington, D.C. January 3rd, 1969, Shirley Chisholm, the first African-American woman elected to the U.S. House of Reps, begins the first of 7 terms. March 22, 1972. Equal Rights Amendment passed by Congress and sent to the states for ratification. September 24, 1981. Sandra Day O'Connor is sworn in as the first female Supreme Court Justice. June 30, 1982. Deadline reached for ERA ratification extension, which falls short by 3 states. July 12, 1984. Geraldine Ferraro, selected by Walter Mondale to be the first female vice presidential candidate representing a major American political party. December 5, 1996. Madeleine Albright becomes the first woman appointed to serve as U.S. Secretary of State. January 18th, 2005. Dr. Condoleezza Rice becomes the first African-American female U.S. Secretary of State. January 4th, 2007. Nancy Pelosi becomes the first female Speaker of the U.S. House of Representatives. January 21st, 2009. Hillary Clinton confirmed as U.S. Secretary of State, serving in the administration of President Barack Obama, the first former First Lady to serve in the President's cabinet. And again, that is the U.S. Women's History Timeline from 1848 to 2009.
Now to Texas, home to one of the most restrictive voter ID laws in the nation. Critics are worried that thousands of minority voters could be disenfranchised. But with Texans heading to the polls now in an off-year election, NPR's Wade Goodwin reports the law is posing unexpected problems for women.
Texas judges are accustomed to a certain level of respect, even deference, as they go about their daily business in the Lone Star State. So imagine Judge Sandra Watt's surprise when she went to cast her vote last week and was told now there was a problem.
What I have used for voter registration and for identification for the last 52 years was not sufficient yesterday when I went to vote.
Why? Because the judge's name on her driver's license lists her maiden name as her middle name, but on the state's voting rolls, the judge's real middle name is there, and that's difference enough to cause a problem.
This is the first time I've ever had a problem voting. And so why would I want to use a provisional ballot when I've been voting regular ballot for the last 49 years?
Tony Pippins-Poole is the elections administrator for the city of Dallas.
You must have a photo ID, and that photo ID has to be one of the listed categories.
For example, it's fine to use a concealed handgun carry permit to vote, but a student can't use his or her university photo ID as they could before. Texas Democrats complain that's because those who carry concealed tend to vote Republican, while university students tend to vote Democratic.
The second part of the photo ID bill is that the name on the ID that you are presenting, that name has to be identical, exactly match what we have on the official list of registered voters.
These voters will either be turned away or allowed to vote provisionally with their ballot set aside. They'll have a week to return to the registrar's office with a passport or birth certificate. If not, their vote is cast out. This worries Mark McKenzie, political science professor at Texas Tech, who's been following the voter ID bill closely. McKenzie says there's not been much training of election officers.
It's unclear to me that the election officers will even inform the voters who vote provisionally that in order for their vote to count, they have to go back and show more documents.
The Texas voter ID law is again before a federal judge in Corpus Christi. Wade Goodwin, NPR News, Dallas.